Hello, and welcome to PubK's 2023 Government Contracts Annual Review. We're thrilled to have almost 5,000 registrants for the 12 sessions that we've had in this program. This is our final day of the 2023 Annual Review. We hope you've been able to join us for as many of the 10 prior sessions that we've already held. We have our final 2 sessions this afternoon. My name is Alan Schwantgen. I'm the president of the PubK Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, and moderator for this year's annual review. The PubK Group publishes 4 newsletters: PubK Law, PubK Compliance, PubK Cyber, and our newest, launched in mid-2022, PubK M&A. Many of you are already subscribers to one or more of these publications, and we very much appreciate your support. Some of you who are joining this annual review are not yet subscribers, but I hope you'll consider becoming a subscriber. Information is at the website shown on the slide or is available from any of the contacts you have at the PubK Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on these next 2 slides. I encourage you to look at the skills and capabilities these firms have and engage them accordingly. Also in 2022, PubK joined with Arnold & Porter to launch a periodic podcast called Bonafide Needs, covering emerging issues and interesting interviews. We'll continue that podcast in 2023 as well and encourage you to access them through our website. If you're interested in partnering with PubK on a podcast, we'd be pleased to discuss this opportunity with you. In lieu of speaker gifts and in honor of our sponsors, PubK is making a contribution to the Capital Area Food Bank. I hope you'll also consider making an individual or an organizational contribution. Since this entire program is being held virtually, all attendees will be in listen-only mode. Your video will remain disabled throughout the session, but we welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many attendees, it will not be possible to answer all of the questions in real time. We are capturing your questions and will endeavor to answer as many as possible at the conclusion of the annual review. Presentation slides for this session are now available on the PubK website, and all presentation slides, along with the audios, will be available for download from the PubK site probably within a week or so of the conclusion of the full annual review. We'll send an email when this information is available for download, how to access it, and for how long the material will be available. We are also applying for continuing legal education approval in Virginia, California, Texas, Florida, Colorado, and Kansas. We've already received approval in Texas and in Florida. And while we cannot guarantee approval in the other jurisdictions, we expect that acceptance within the next few weeks. Again, we'll notify all attendees when those approvals have been received. If you've registered and are interested in obtaining CLE, please look for the 2 poll questions we have during this presentation, 1 each hour. State boards require us to verify your participation during the event. We'll keep track of the responses to verify that you viewed the panel. And if you don't wish to obtain CLE credit, you can disregard the poll or just answer for fun. Now I'm thrilled to continue this 8th PubK annual review with our session 11 panel on the False Claims Act, FCPA, fraud and enforcement. Our distinguished panel members are my partner, Nichols Lew, Andy Lew, Aaron Beasley from Bradley, Aaron Bolt Cummings, and Jen Short from Blank Rome. Jen, over to you.
Thanks so much, Alan. All right, let's jump into it. This is a quick overview of what we hope to cover in the next hour and 50 minutes. I'll start with the False Claims Act recoveries by the numbers. We don't have them yet, little preview. We'll get into some False Claims Act developments on cases, regulatory matters, and some policy initiatives. We'll talk about Chief Compliance Officer certifications and DOJ's revised approach or new approach to corporate prosecutions, and key FCPA development, so getting into the Foreign Corrupt Practices Act for a little bit, and then some trends and the forecast for 2023. So that's our agenda. Let's go to the next slide. As I previewed, we don't have numbers yet from DOJ. Every year, DOJ issues its statistics on its False Claims Act recovery numbers. The report has been getting later and later every year. Last year, we didn't see the results until early February of 2022. So we are still waiting for the statistics on fiscal year 2022 recoveries. We're now, as everyone knows, in fiscal year 2023. But here's what we can anticipate, and I feel fairly confident about some of these predictions as to what we'll see coming out of DOJ. As we've seen in years past, we can anticipate that there will be a handful of blockbuster settlements and resolutions. The ones that come up to mind for FY 2022, the $900 million Biogen settlement. That was a healthcare anti-kickback statute case. It is notable because it was a case that the government declined to intervene. The relator went forward and litigated that case for several years and then resolved it, the largest declined PTAM case resolution to date. We can also expect that the stats will highlight the Mallinckrodt decision or the Mallinckrodt resolution at $260 million, another anti-kickback statute case. Significant because it was a $260 million settlement with a company that is in bankruptcy. So that was an ability to pay resolution at $260 million, fairly significant there. The $166 million Centene Corp False Claims Act resolution is actually, we probably won't see that in the federal DOJ statistics because that was a state AG False Claims Act case out of Texas. That case is notable because it highlights some of the collateral consequences that companies can face when they have False Claims Act matters. So the company recently estimated that it's going to pay about $1.25 billion in recoveries resolutions with the state AGs across a number of states. It involves overcharges to state Medicaid programs. On the heels of that announcement, the company then was slapped with a shareholder derivative action against a number of board members and its executive team. So those are the types of things that, as False Claims Act practitioners, we try to be aware of. What else is coming out of this? Also highlights what we can anticipate coming from the DOJ stats. We'll see other healthcare fraud cases resolving in the tens of millions of dollar range. And as we've seen historically, contracting and grant fraud cases, resolutions at lower dollar amounts, but that doesn't mean there hasn't been a lot of activity on that front. And one prediction that I will make, I don't think I'm going too much out on a limb, but I suspect that we will see increased numbers of whistleblower filings in fiscal year 2022. And I base that prediction on some of the DOJ initiatives that have been announced over the last couple of years. I'm handing it over to Andy to talk about one of those.
Thanks, Jen, and good afternoon or good morning to everybody, depending on where you are. So I'm going to talk a little bit about the DOJ's Civil Cyber Fraud Initiative, because there were a few developments that I'll get to in a minute in this past year. And we spoke about the creation of this initiative when we did this annual review last year. So this initiative was launched in October of 2021. And just as a reminder, it's an initiative with a stated goal of using the False Claims Act to pursue cyber-related fraud by government contractors. And the initiatives specifically stated that they were going to use the False Claims Act in three specific ways against companies. First, by pursuing those that knowingly provide deficient cybersecurity products or services. And second, by pursuing those who knowingly misrepresent their practices or protocols. And third, against those who knowingly violate their obligations to monitor and report cybersecurity incidents and breaches. And there's a lot of challenges, obviously, for government contractors in this area. Among them, that there are these ever-changing kind of cyber standards that basically set up moving goalposts in terms of targets and in terms of, what standards they have to comply with. And so the last thing I'll note about kind of this area in general is that, in my view, it's an area that is really kind of ripe for a lot of whistleblower activities. And that's because, we're talking about cyber professionals who, if I'm going to just overly generalize, are more likely to be whistleblowers than perhaps, other just general classifications of employees, right? These are cyber professionals whose, main job is to ensure that there are no cyber incidents and secure systems. And so they're often not as understanding about kind of the business necessities in terms of need for balance, the need for limited, resources that may hinder their goals. And they frankly they don't want to take the blame, right, if something goes wrong. So they are often the squeaky wheels. So that's just kind of a little bit of context for this initiative. Next slide. So this past year, we saw the first two cyber initiative settlements. And the first was a $930,000 settlement with Comprehensive Health Services, or CHS. And interestingly, while in DOJ's press release about this matter, it touted it as the first settlement under the cyber fraud initiative, but nowhere in the settlement agreement itself does it ever mention cyber. And I think in part, it's an indication of kind of how broad the use of the term cyber is here, right? So CHS is a provider of medical services at overseas government-run facilities. And the contract that CHS had included within it costs to have a secure electronic medical record system to store the confidential medical records, right, for the patients that they were seeing. And the allegation is that they failed to store the medical records solely on that system. And so what would happen is they would scan the documents, so scan medical records to put into the secure system, but they left them on the unsecure internal network drive. And that is the basis for the non-compliance with the contract that required that all the medical records be stored just on a secure system. The second settlement that happened under the initiative last year is a $9 million settlement with Aerojet Rocketdyne Holdings. And we've talked about this case in the past too, because it's one of the first QUITAMs that focused on misrepresentations about cyber compliance. At the motion to dismiss stage, the defendant had argued that, among other things, the government, was well aware that it had not was not in compliance with all of the requirements, but the court rejected and denied the motion, holding that it was possible that even if that was true, there may have been a misrepresentation about the extent to which the defendant was non-compliant. So the case proceeded through litigation, and at the motion for summary judgment stage, the defendant argued that the non-compliance wasn't a material falsity, which the court rejected. And Aaron's going to talk more about this case and that holding later, so I'm not going to talk about it here. But in short, the case went to trial, and I believe it was on the second day of trial, the parties settled the case. This is a case in which the government did not intervene, and so it was the relator and the defendant that settled, obviously with DOJ's approval. So those were the developments last year. I think, there's no doubt that we're going to see more of these cases in the future for some of the reasons that I had mentioned earlier, about the whistleblowers being cyber professionals, these ever-changing standards, and then frankly, it's hard to meet these standards. So more to come in the years ahead. Next slide.
All right, I'm taking it back from you, Andy.
All right.
So the other DOJ initiative where I suspect we'll see more related whistleblower False Claims Act filings is with the procurement collusion strike force efforts. Now, the PCSF itself was an initiative announced by DOJ criminal antitrust back in late 2019. Just on that front, recently, so November of this year, there was an announcement that the strike force is adding some additional enforcement partners, and these are notable. So you've got DOE, OIG, Interior, OIG, Transportation, OIG, and the EPA, OIG. The announcement of those, bringing those new enforcement partners into the strike force collaborative, it was directly tied to the Infrastructure CHIP Act and other spending that is anticipated will go out through those agencies. And so I think we can anticipate seeing increased activity from the government side and from the government antitrust enforcement side through the strike force in these areas in particular. So what we have seen since the strike force has been in place, we have seen some announcements about strike force activity over the last year in 2022. And what we see is for government contractors, a wide range of criminal charges and criminal resolutions, ranging from bid rigging, small business fraud, allegations of kickbacks, bribery, attempted monopolization. So you see a variety of different charges and cases being brought through this strike force initiative. I think one thing that strikes me when I'm looking through those announcements is that while there are some antitrust charges included in those cases, a lot of times it seems that the strike force investigations is really leading to other types of criminal charges. So kickback charges and bribery charges, just government, general programs fraud type enforcement that is getting resolved, but it's under the umbrella of the strike force. And I think just based on what I see on my desk day to day, I think the heightened awareness of those antitrust type issues is leading to whistleblower cases. At least that's what I suspect based on my conversations on behalf of clients in the last couple of years. So what we see in the False Claims Act is sort of an uptick in questions and investigations that involve that seem to have antitrust overtones. And we're getting questions about teaming agreements and relationships between contractors and vendors, between competitors within a particular area, and inquiries on how pricing is being arrived at. And we can tell with some certainty that there are whistleblowers behind some of these initiatives. And then in other matters that I know about, it's hard to tell, is it a whistleblower initiative or is this something that maybe either DOJ is coordinating with the civil division or a self-initiated DOJ inquiry. But we are seeing some of those sort of antitrust overtones to some of the False Claims Act investigations that I've seen. Not surprising if the strike force is out in the news and in the world and they're starting to report results. It's not surprising that there are whistleblowers out there that want to try to monetize through the False Claims Act things that they may be seeing. So we hit now quickly on potential settlements and recoveries that we'll hear more about from DOJ in the upcoming weeks. These DOJ initiatives. Aaron, I'm passing the baton to you to start us off talking about recent case law developments.
Fantastic. Thank you, Jen and Andy. So switching gears now, I think we can go to the next slide. We're going to talk about significant case developments from 2022 in the False Claims Act context. We're going to start by running through a series of cases that interpret and opine on the materiality element, which continues to be one of the most litigated over elements in the False Claims Act context. The first case that we wanted to highlight for everyone is a case out of the DC Circuit, and that's the case of Vermont National Telephone v. North Star Wireless. In that case, the relator alleged that telecommunications companies defrauded the government of $3.3 billion by manipulating FCC rules and falsely certifying their eligibility for discounts on spectrum licenses. The district court ended up dismissing the suit, resting its decision primarily on the False Claims Act's demanding materiality standard. An appeal then ensued. Next slide. The DC Circuit ended up reversing the trial court, holding that the False Claims Act's materiality inquiry, quote, focuses on the potential effect of the false statement when it was actually made, not the actual effect after the fact. According to the DC Circuit, the defendants alleged false certifications and failures to disclose side agreements to the FCC during the license application process at least had the potential to impact the FCC's eligibility determinations at the time they were made. Next slide. The next noteworthy case in the materiality context that we wanted to highlight is a case out of the Fourth Circuit, and that's the case of Taylor v. Boyko. In that case, the relator alleged that a clinical care staffing company's failure to file an annual report and pay a $25 fee and the consequent loss of its certificate of corporate authorization and associated regulatory violations were, quote, so central to the medical services provided that the Medicare program would not have paid those claims had it known of these violations. The district court, however, disagreed with the relator, and then the relator appealed to the Fourth Circuit. Next slide. The Fourth Circuit ended up affirming dismissal, reasoning primarily that the defendant's failure was, quote, bureaucratic rather than material. According to the Fourth Circuit, the relator, quote, did not allege that these failures impacted or influenced the medical services provided or the medical qualifications of the physicians employed, which, according to the Fourth Circuit, is what the government was paying for all along. Next slide. Another noteworthy case in the materiality context is the case of US v. Vora, and that's a case out of the Western District of Kentucky. In that case, the government alleged that a laboratory paid a doctor so that he would order unnecessary and unauthorized tests, including more than 1,000 tests that Medicare ended up reimbursing. The government also alleged that the doctor falsely certified to Medicare that the tests were medically necessary. Next slide. The district court ended up holding that the government's, quote, decision to file a False Claims Act lawsuit that describes a regulation as material cannot itself prove materiality. In addition, the court ended up rejecting the government's attempt to rely on after the fact, mid-litigation rejection of the same claim that it sought to litigate in that case. Next slide. Another noteworthy materiality case is the case of Gel v. GGNCS South Haven. That's a case out of the Fifth Circuit. In that case, the relator alleged that a nursing director's out-of-state license was invalid in North Carolina due to her falsely certifying a different state as her primary residence. The district court granted summary judgment in favor of the defendant because, among other things, the relator failed to establish materiality. The relator then appealed to the Fifth Circuit. Next slide. The Fifth Circuit ended up affirming because, among other things, the relator's evidence, quote, shows no linkage between nurse licensure and the amount the government pays to the defendants in satisfaction of their submitted claims. Thus, even if there was a regulatory breach, the relator could not establish that it was material in these circumstances. Next slide. The next case that we wanted to highlight and that Andy talked about a little bit above, and that I think many folks have probably heard about, is the case of Marcus v. Aerojet Rocketdyne. And that was a case that was pending in the Eastern District of California until it settled this past summer. In that case, the relator alleged, among other things, that the defendant falsely certified compliance with DFAR's clause 252, 204, 7012, which is the Safeguarding Covered Defense Information and Cyber Incident Reporting Clause. The relator and the defendant filed cross motions for summary judgment, and the government, although it did not intervene, filed a statement of interest in the case. Next slide. The court ended up denying summary judgment, stating in relevant part, quote, "The mere fact that a regulation is a requirement does not dispositively mean that it is a condition of payment or that it is material. However, it does not follow that the incorporation of a regulation as a condition of the contract may not be taken into account in determining whether compliance with the regulation is material." Now, if you are a False Claims Act defendant, you'll probably be citing the first sentence of that holding. And if you are the government or a relator, you'll probably be citing the second sentence of that holding. Next slide. And with that, I'm going to pass the slides off.
Thanks, Aaron. So the next series of slides is going to talk about two separate topics. They're two distinct lines of cases, but I think that they're related. The first is the line of cases dealing with objective falsity. And these are cases involving whether the government or the relator has to prove that a claim is objectively false, right? And the second line of cases that we'll talk about after that is what some of us call the SafeGo issue. And those are cases involving whether the False Claims Act's scienter requirement is met if a defendant acted on an interpretation of a statute or regulation that turned out to be incorrect, but that the incorrect interpretation wasn't objectively unreasonable. So first, with respect to the objective falsity cases, there's a circuit split on this issue. Some last year we thought that the Supreme Court would resolve the circuit split, but it has thus far declined to grant cert in any of the cases that have come before it. The 11th Circuit has required objective falsity, and the 3rd and 9th Circuits have found that even subjective opinions can give rise to False Claims Act liability. So in both the Acera case and alternative cases, the question was whether a doctor's subjective clinical judgment as to medical necessity could be deemed false, right, under the FCA, or whether the claim had to be supported by facts that could be proven to be objectively false. And so just to highlight kind of how these issues come up, and they often do come up in the healthcare cases, but they can also come up in procurement fraud cases. So in the Acera care case, it was alleged that the hospice provider overbilled Medicare for services. And in particular, these were hospice benefits for patients who were diagnosed as terminally ill. And the primary issue in the case was whether a difference of opinion between doctors could support FCA liability, where the government had argued that, well, a majority of the patients weren't terminally ill, as had been diagnosed by the treating physicians, and should not, therefore, have received the hospice benefits. The district court granted summary judgment in favor of the defendant, finding that there was a reasonable difference of opinion as to whether these patients were terminally ill, and that sort of reasonable difference of opinion can't support a claim of falsity under the False Claims Act. DOJ appealed that and lost at the 11th Circuit, which upheld the district court's holding. And in contrast, the Third and Ninth Circuits have rejected the objective falsity standard. And they've done so in different ways, with the Third Circuit really kind of distinguishing between factual falsity and legal falsity, holding that legal falsity concerns false certification of a claim to the government, right, rather than the facts of the claim itself. And so there's a little bit of a distinction in how they're approaching these cases. Last year, the Ninth Circuit revisited the issue, or actually there's a case that's going to be pending before it, and that's in the DeVita case. And that is a case that involved whether DeVita provided medically unnecessary products and services and unreasonably expensive medications. The Ninth Circuit affirmed the dismissal of the case and found that the complaint didn't show why the dispute was more than just a disagreement in clinical judgment. And as such, the relator didn't raise a plausible inference that the certifications of medical necessity were false or fraudulent. Next slide, please. So those cases that we just talked about arise in the context of falsity, but they kind of dovetail with the cases that address the issue of scienter, and whether reasonable interpretations of ambiguous regulations and statutes can give rise to liability. And so I'm going to give a little bit of a background first, and this is the so-called Safeco issue. The Safeco case is a Supreme Court decision from 2007, and it is not a False Claims Act case, but rather a case under the Fair Credit Reporting Act. And the Supreme Court in that case held that a company did not willfully, which is the term used in the FCRA, violate that act when it acted on an interpretation of the statute that was ultimately incorrect, but not objectively unreasonable. And when a court finds that under the FCRA that the interpretation of the statute was reasonable, you never even have to look at the defendant's subjective intent or whether it actually held that belief. As a defense lawyer, find this case extremely helpful to extend to the False Claims Act because of the parallels between the two statutes. Under the Fair Credit Reporting Act, the terminology is willful, which kind of equates, in my view, under the False Claims Act to the reckless disregard standard under the FCA. Next slide, please. So there's a number of cases that have arisen over the past few years, including last year, about whether or not it's appropriate to extend the Safeco holding to the False Claims Act. And as you can imagine, there's this vehement disagreement between the two sides as to that. And there's a number of these cases that are currently pending in terms of petitions for cert before the Supreme Court. And I imagine that we will hear in the relatively near future as to whether or not the Supreme Court is going to grant cert to address this issue or not. So in the Sheldon v. Allergan case, the Fourth Circuit did apply the Safeco standard to the False Claims Act. It was not a unanimous decision. The majority held that the defendant does not knowingly, as that term is defined in the False Claims Act, act under the FCA if it has an objectively reasonable reading of the statute or regulation, and there was no authoritative guidance or warning against the erroneous view. And that really does parallel what the Supreme Court had held in the Safeco case. The dissent disagreed and accused the majority of eliminating the actual knowledge or deliberate ignorance standard under the FCA by not looking at what the defendant's subjective intent was. Next slide. And in a second Fourth Circuit decision, it similarly extended the Safeco standard to the FCA. And the dissent there was a little bit different and just said that the dissent would have allowed the jury to take a look at whether or not there was deliberate indifference there on the part of the defendant. Next slide. In the Seventh Circuit, there's the Proctor case, and this is one of the cases that I believe petition for cert is pending before the court. The Seventh Circuit applied the Safeco standard, and it also provided some additional guidance as to what it means for there to be authoritative guidance that may warn away the defendant from the erroneous reading. And it held that to be authoritative, it must come from a source with the authority to interpret the relevant texts, and that's a fairly high bar. And it also has to be specific enough to put the defendant on notice that its conduct in particular is unlawful. And so the vague kind of guidance that doesn't apply directly to the defendant's conduct may not be authoritative guidance. The United States v. Sigma case is a case that is currently on appeal to the Ninth Circuit. And so the Ninth Circuit is going to have to address this issue. In the Sigma case, the defendant was alleged to have falsely claimed on some customs entry documents that the parts that it was importing were not subject to any anti-dumping duties when in fact they were. And what the defendant argued was, well, there were some orders that may or may not have applied to the parts in question, but there was some ambiguity as to whether or not the parts were within the scope of a Commerce Department's anti-dumping order, and whether or not, the pipe fittings in this case were actually covered. And that as a result, right, the ambiguity in that order vitiated any scienter requirement under the FCA, and that you never had to even look to see whether or not they actually believed or knew whether or not these parts were subject to the order. The district court rejected Sigma's argument, let the case go to the jury, which ultimately found that Sigma's interpretation wasn't reasonable. And so we'll see what the Ninth Circuit says about that. Next slide. And I think I'm turning this back over to Jen.
Yeah, and I'm going to interject here just real briefly. We're going to have our poll for the CLE question, CLE certifications. If you want CLEs, please respond to this poll. We'll leave it up for about 2 minutes. And I'll turn the time back over to you, Jen. Thank you.
Hi, Jen, I'm not sure if you're muted, but I at least can't hear you.
Somehow I've been cut off.
Oh, now you're back.
Okay, can I get to the next slide? Everything I just said was unimportant.
It's amazing. Yeah.
But it was amazing. I wish you could have heard it. Apologies for that. Okay, in the False Claims Act world, the Medicare anti-kickback statute sort of rules with those blockbuster resolutions that we see year after year, at least in recent years. But for this audience, I want to flip in the next slide to the AKA, the Anti-Kickback Act that applies to government contractors. But no, back to the AKS. Sorry, I do want to talk about this because even though the AKS and the AKA are different statutes, they do share some similarities. So pretty quickly on the Medicare anti-kickback statute, there have been a few interesting developments in the Medicare AKS world that I think might be relevant or cause us to think about some approaches under the AKA. So one development this summer was in the Cairns versus DS Medical case, where the Eighth Circuit sort of threw a wrench into the works. The DOJ and relators had been humming along with this view, pushing this view that had been adopted by the Third Circuit at least, and by a number of trial courts, that if there is an underlying anti-kickback statute violation, so a payment or some form of remuneration to induce the referral of services or goods that would then be reimbursed by federal healthcare programs. Once you have that violation, the False Claims Act violation was almost presumed. The notion was that that underlying kickback issue would taint all of the resultant claims. And there's been a lot of litigation about how far does the taint extend? How far can you make that assumption? And then the Eighth Circuit this summer came in and said, you know what, we're just going for a but-for causation standard. So you might have, and the government or a relator might be able to show that there was a kickback violation, that there was that payment with the one purpose, at least one purpose of which was to induce a referral. That's all fine and good. But if you want to try to make a False Claims Act case out of that, then plaintiff, you're going to have to show that but for that payment, the claim for the services would not have been submitted. And I know Aaron's going to talk about that some more in a little bit, because it's an important development in this world, because it is upsetting the apple cart a little bit. You'd think that coming out of that, maybe DOJ would back off of AKS violations or take a pause. You know, can AKS violations still form the basis of FCA liability? We haven't seen it yet. The Biogen resolution was at least announced after the DS Medical case. That was a big kickback case. That was the $900 million that was recovered by the relator, and also in the Mallinckrodt case, different forms of kickbacks, right? And that is still, you know, eventually, if the DS Medical approach, the Eighth Circuit approach sort of takes hold, that view will no doubt influence settlement discussions with DOJ, but so far we haven't quite seen it. The other interesting thing that has happened in the last year on the Medicare AKS side is that Pfizer really took a seemingly aggressive view, but they presented this question on a cert petition that was recently rejected or denied by the Supreme Court. But Pfizer had posed the question, does the AKS, the underlying violation, have a requirement that the person offering the inducement intend to corrupt the prescribing physician or the service provider's medical judgment? The Supreme Court rejected that cert petition, but there are other, largely in the pharmaceutical field, defendants in cases that are raising this question. You know, is that part of the Medicare AKS elements? So we'll see where those two things go. Now let's go to the next slide. Those are interesting arguments and things to think about as we look at the Anti-Kickback Act that applies to contractors. And here, sort of similar to the Medicare AKS, the AKA prohibits giving or receiving anything of value or compensation to improperly obtain or to reward favorable treatment in connection with the prime or subcontract. What's interesting to me about the AKA is that frequently those investigations and those allegations really wind up getting wrapped up in other issues. So frequently you will see issues involving potential bribery or conflicts of interest, Procurement Integrity Act violations. The fact patterns sort of lend themselves to being, you could have potential violations bucketed a number of different ways. And then the question of how do you then translate that underlying violation, AKA or otherwise, into False Claims Act liability. So we don't see that much activity that talks about Anti-Kickback Act violations as being sort of the predicate or underlying violation leading to FCA liability. But we did this year see a couple of notable resolutions that were targeted to AKA violations. One is the KBR case. There, the case had been litigated and fought, was scheduled for trial, and KBR and the other defendants reached a $13.67 million settlement to resolve the KETAM action and then some other allegations that the government had investigated, based largely on kickbacks from subcontractors who were giving kickbacks to KBR and other defendant executives, and then inflating their costs to the government to cover the payments. The other case was a follow-on resolution of the mock settlement last year. This time the settlement was $302,000 with Wise Services, who was the subcontractor in that situation. And there the allegation was that the subcontractor was paying kickbacks to the prime contractor, to mock services, and basically the payment was to cover up false invoices. So the invoices were not just inflated, but apparently entirely made up, was the allegation. So when we look at those cases and we think about the Medicare AKS developments on the case law, I think there's some room going forward for contractors to make arguments about, what does it mean? Do we need to be able to show but-for causation in this circumstance? But for a payment from a subcontractor, would the subcontractor not have received the contract? Because sometimes those issues can be really fuzzy. And then, what do the terms of the AK mean when it talks about improperly obtaining? What is that improper standard or rewarding favorable treatment? So let's talk more about but-for causation. Aaron.
Actually, Jen, can I make just a couple other thoughts about the AKA, which I find interesting is, under the AKA, there's both civil and a criminal component to it, right? And so these are cases that could be pursued by the government civilly under the AKA, but right, they are often pursued under the False Claims Act, both because you've got whistleblowers, right, who have to proceed under that, and because you can get treble damages. And so I think that's why a lot of times we see these cases being brought as FCA cases and not AKA cases. And the second interesting thing is that when you look at things, cases like the KBR case, right? As I recall the facts of that case, at least, those were kickbacks that didn't benefit KBR, right? So these are KBR employees who were taking kickbacks, right, from a subcontractor, but the FCA liability, right, goes to the company, which is a scary thing for a lot of contractors, I think.
Yep. And on to your point on the ability to pursue AKS or AKA violations criminally or civilly, right? So there's a difference in what the recovery can be civilly, and also a difference in the burden of proof if you're pursuing those claims criminally. So that's another reason that we wind up in the civil bucket sometimes with those cases.
Right.
Yes, good points. Danger zone for companies.
Fantastic. Before we move on to 9B pleading standards, wanted to just quickly hit a little bit more the issue of but-for causation that Jen had mentioned. Next slide. And talk a little bit more about the case of Cairns v. DS Medical that Jen mentioned. And again, that's a case out of the 8th Circuit from 2022. So in that case, the relator and the government alleged that the defendant violated the False Claims Act by submitting false Medicare and Medicaid claims after violating the anti-kickback statute by repeatedly using spinal implants that were made by the defendant's fiance's company, and then allegedly receiving stock from his fiance's company. Now, the relator and the government took that case all the way to trial and prevailed. And then the defendant ended up appealing to the Eighth Circuit. Next slide. So in relevant part, the Eighth Circuit ended up holding as follows. There are several ways to prove that a claim is false or fraudulent under the False Claims Act. One of them is to show that it includes items or services resulting from a violation of the anti-kickback statute. This case requires us to determine what the words resulting from mean. We conclude that it creates a but-for causal requirement between an anti-kickback violation and the items or services included in the claim. In this case, the district court did not instruct the jury along these lines, and accordingly, the Eighth Circuit ended up reversing and remanding for a new trial. Next slide. On to 9B pleading standards and kicking it over to Jen, I believe.
Yes, indeed. Okay. So back to some interesting potential Supreme Court jurisprudence that is not going to happen. I feel like a lot of my topics here have been like, nothing's happening on this, or nothing has happened yet. So once again, nothing is happening at the Supreme Court level about whether Rule 9B in the context of a False Claims Act action requires a plaintiff, typically a relator, to identify specific false claims, that submission of the claim seeking payment from the government. There's been a circuit split that has been around for some time now, dividing between courts, circuit courts that say, in order to meet Rule 9B, you have to be able to identify a claim, right? The claim is the basis for False Claims Act liability. So what's that claim? When was it submitted? Why is that claim false? And they're looking for that level of detail versus courts who say, well, wait a second, if you can detail that there was a fraudulent scheme, and we can sort of fill in the gaps a little bit to assume that this must have led to the submission of false claims to the government. So that's roughly, very generally speaking, the circuit split. There were 3 different petitions for cert that were in front of the courts, the Supreme Court this year. It looked like the court might be interested in looking at this issue because there were 3 different cert petitions. Interestingly, this is like one of the places where defense counsel and relators counsel seem to agree that yes, there is a circuit split. And this is a case, this is an issue that the Supreme Court should weigh in on. Or at least the relators here thought that the Supreme Court should weigh in at this juncture. The court asked DOJ to chime in, asked the United States to chime in. It did. DOJ came out with its brief saying, well, there's not really a circuit split. There was a circuit split, but really the courts are converging on an appropriate standard. And so now is not the time. The petitioners in front of the court, and again, the defendants in front of the court, everybody was saying like, yes, there is a circuit split. Court, this is, the courts, the different circuits apply different standards here. And the Supreme Court said, yeah, we'll pass again. The same issue was raised back in 2014 and 2018 and a couple other cases. And the Supreme Court just doesn't seem to want to weigh in on this. So not this year. Maybe in 2024, we'll see what happens.
Although it's hard to imagine, given how many times they've denied cert, like what it will take for them to actually grant cert, and it's one of those issues where I think, especially maybe more so in the healthcare industry, but where there's a lot of venue shopping by relators as to where to file,
right?
Yeah.
Exactly, and I think the point that DOJ was making, in that the courts are sort of kind of coming around to some exceptions to this hardline rule about identification of specific false claims, kind of in recognition of the notion that not all relators are going to be involved in the submission of actual claims. They're not necessarily going to have that data even after the government has investigated. Maybe the government has access to claims data, but DOJ typically doesn't hand that information over to relators, sort of frowns upon whistleblowers amending complaints to include information that came from a DOJ investigation. So relators are somewhat hamstrung in that regard. And then there's the tension of like, hey, on the defense side, you've got this allegation of fraud, but you need to have a claim in order to get to False Claims Act liability. So, the courts are sort of struggling with that, and it may be a mess, and maybe the Supreme Court will look at it someday when it's a complete mess. We can move to the next slide to provide an example of when the court does start is when things have become a complete mess. So next slide. We will hear from the Supreme Court on the issue of what is DOJ's authority to force a dismissal of a QTAM action under 3130C2A after DOJ has declined to intervene in a case and over the objection of the relator, the whistleblower. So here, over the last several years, there's historically been this split between the DC Circuit's articulation of unfettered discretion, right? This case is brought in the name of the United States. The United States has prosecutorial discretion to dismiss a case where it is the real party in interest. And then the Ninth Circuit and the Sequoia Orange Standard had articulated this, there needs to be a valid government purpose to dismissing a case over the objection of the relator. A lot of discussion over, I guess, in more recent years, when DOJ, the Granston memo, renewed its policy of actually pursuing C2A dismissals. There's been a lot of hand-wringing on a couple of different issues. The False Claims Act has this provision or provides for a hearing in that circumstance. What does a hearing mean? What's the purpose of this? Why is that provision there? What is the role of the court? And then sort of secondarily over the last year or so, circuit courts really struggling with what's the correct procedural posture here, especially if a case has been pursued for a number of months or years into litigation. Does the DOJ, does the United States get to jump back in solely for the purpose of filing a motion to dismiss? Does it need to seek to intervene in the case so that it can dismiss? What's the procedural posture? And over the last couple of years, there have been some interesting sort of twisting ourselves into procedural pretzels to try to figure out what is this C2A authority. So at the end of the day, and I think we talked about this last year, at the end of the day, whether you apply the unfettered discretion standard or valid government purpose standard, whether this is a Rule 41 dismissal standard, or there's intervention, an implied motion to intervene, which will automatically be granted, or no matter what you come up with, at the end of the day, the government was allowed to dismiss the cases, right? So the government moves to dismiss, motion granted. Interestingly, in the Polanski case, which is the one that is before the court this term, Polanski, the relator, after many years of litigating this case, and so we've got a sympathetic relator who has litigated for a number of years without the support of the government. Government comes in, dismisses the case. So Relators Counsel argued to the Supreme Court that under the language of the False Claims Act, the United States loses its authority to dismiss altogether when it declines to intervene in the case. And that raised some interesting arguments. The reports of the case was argued in early December. Reports coming out of the arguments in front of the Supreme Court suggest that the court is not going to adopt the relator's argument there. There are some constitutional issues. How can you say that the United States doesn't have the authority to administer cases where it is the real party in interest, where it's the named plaintiff? So the court seems skeptical of that argument. but we may finally get some standard on what needs to happen procedurally and from a standard of what the government would need to show in order to dismiss an FCA case over the objections of a relator. My prediction is at the end of the day, the government's going to be able to meet that standard in 99.9% of the cases. So we might get some clarity. To me, this isn't as interesting an issue as the 9B issues or certainly the Safeco issues, but we'll get something and we'll update you next year. All right, turning it over to Aaron to talk about damages.
There you go. Next slide. So on to the issue of damages. There was one case in particular from this year that we wanted to highlight for everyone. And that's the case of United States v. Honeywell. It came out of the DC Circuit. In that case, the United States sued Honeywell for providing the material in allegedly defective bulletproof vests that were sold to the government. The government then settled out with the other companies involved, and Honeywell sought a pro tanto, a dollar-for-dollar credit against its damages liability. The district court, however, denied Honeywell summary judgment on the issue of measure of damages offsets, but the district court allowed Honeywell to file an interlocutory appeal. Next slide. The DC Circuit weighed in and stated in relevant part, quote, "The False Claims Act does not provide a settlement offset rule, nor does it include a common law term incorporating such a rule. This case presents the rare circumstance in which this court must establish a common law rule to govern damages arising from federal law. We reverse the district court and hold that the pro tanto rule is the appropriate approach to calculating settlement credits under the False Claims Act." So, most noteworthy case in the damages context in 2022. Next slide. Switching gears now, I'm going to talk about some cases that discuss the public disclosure bar. The public disclosure bar prohibits a relator from bringing a False Claims Act suit based on fraud that has already been disclosed through certain public channels, unless the relator is a, quote, original source of the information. Next slide. The first case we wanted to highlight is a case out of the Ninth Circuit, and there was a lot of activity out of the Ninth Circuit this year, actually, in the public disclosure bar context, for one reason or another. But the first case is Mark v. Shamir, USA. In that case, the relator alleged that the defendant, which was an eye lens manufacturer, violated the False Claims Act by causing fraudulent bills to be submitted under government insurance plans, where the defendant charged customers a lower rebate price, but then charged the government a higher non-rebate price. The district court held that the relator's allegations were barred by the public disclosure bar because they were very similar to promotional articles published by the defendant itself about the rebate process. The relator then appealed to the Ninth Circuit. Next slide. The Ninth Circuit ended up reversing the district court, finding that, quote, the information disseminated publicly by the defendant was so innocuous that there was no public disclosure of a transaction or an allegation of fraud in the first instance as required by the False Claims Act. Next slide. Another noteworthy Ninth Circuit case, the public disclosure bar context, is the case of Silbershire v. Allergen. In that case, it was a patent attorney of all people who brought the key TAM action, alleging that pharmaceutical manufacturers fraudulently obtained patents in order to protect their brand name drugs from competition from generic drug competitors. The district court denied the defendant's motions to dismiss, and then the defendants appealed to the Ninth Circuit. Next slide. The Ninth Circuit ended up reversing the district court and holding that even though the public disclosure bar was in fact triggered in that case, the relator could still bring his qui tam action if he is a quote original source of the information in his complaint. The district court, however, did not reach the original source issue, and accordingly, the Ninth Circuit remanded to the district court for further proceedings. Next slide. Yet another Ninth Circuit public disclosure bar case, Roe v. Stanford Health. In that case, the relator alleged that the defendant engaged in certain fraudulent Medicare billing. The district court dismissed the relator's complaint, quote, relying on the False Claims Act's public disclosure bar, because much of the complaint was premised on information that was obtained by the relator through a Freedom of Information Act request. Next slide. The Ninth Circuit ended up affirming in pertinent part, thereby joining the majority of circuit courts in holding that materials that are released by a government agency under the Freedom of Information Act can in fact trigger the public disclosure bar. Next slide. With that, I'm going to pass the slides back over.
All right. Thanks,
Thank you.
Aaron.
Hey, Andy, I'm going to interject one more time and launch the second poll. If you're interested in CLEs for this session, please respond to the poll. We'll leave this up for about 2 minutes, and I'll let you get back to it, Andy. Thank you.
Thanks. You could move to the next slide for me, please. So it was probably starting a decade ago or so. We saw a lot of cases, a wave of FCA cases that involved fraud in the area of set-aside contracts for small businesses, Native Alaskan businesses, service disabled, veteran-owned businesses, and the like. And this past year, we saw several more, including one that settled for $48.5 million, which is the largest amount ever for an FCA small business case. And the facts here are interesting. So the defendants were Trimark and its wholly owned subsidiary, Gill Marketing, Gill Group, which Gill did the federal work for Trimark, and they provide kitchen and food service equipment to the government. And what happened was they had entered into arrangements with at least three different service disabled, veteran-owned small businesses and other veteran-owned small businesses to get set-aside contracts that they weren't eligible for themselves. And this isn't a case in which the defendant, misrepresented their size or their status. Instead, it's a case in which they were alleged to have put these small businesses up as the face of the contract, but in actuality, it was really Gill that was doing all of the work. They allegedly emailed the government using the small businesses' email accounts. It was Gill that prepared all the proposals, set the pricing, et cetera, allegedly. And then, the small veteran-owned businesses got paid just 1 to, I think, 5% markup, with the rest of the money all going to Trimark/Gill. So there are a few interesting things about this case. First is that it was a qui tam, and even though I don't think that the president of Gill Group was named as a defendant in the qui tam suit, the government settled with that president for $100,000, which is consistent with DOJ's kind of emphasis and stated goal of holding individuals accountable. The second interesting thing I thought was, these small businesses were in essence resellers of Trimark's kitchen equipment. They weren't manufacturers. And in that sort of setting, it's not unusual for larger companies to have, reseller networks that include resellers that are eligible for set-aside contracts. But here, what clearly troubled DOJ, which had intervened in the case, was the extent to which the defendants had exerted control over the entire process and making them, in essence, affiliates. The next slide, please. And And the third thing I'd point out is the government also settled with the prime contractor. So this is a separate qui tam suit by the same relator against what I believe is the prime contractor in some of the underlying fraud in the prior case that we talked about, and settled for $2.8 million, believing that the prime contract should have known that these set-aside contracts were really pass-through contracts on behalf of Trimark, and as such, they weren't entitled to the monetary credit that they were receiving for meeting their small business contracting goals. So that's that. Next slide.
Great.
That I'll turn it back over to, I think it's Aaron.
Thanks, Andy. Switching gears now, we're going to talk quickly about case developments in the FCA retaliation context. So the False Claims Act, as many of you know, protects whistleblowers from retaliatory actions for reporting, investigating, or trying to end fraud against the government. The first case that we wanted to highlight from 2022 is a case out of the Sixth Circuit, and that is the case of Khalil v. Oakwood Healthcare. In that case, a podiatrist brought an action against multiple hospitals, asserting a claim for violation of the whistleblower provision of the False Claims Act for allegedly being retaliated against by his employer because of his assistance with a False Claims Act investigation. In that case, the district court granted summary judgment to the defendants, holding that the 3-year statute of limitations for a retaliation suit under the False Claims Act had already expired. The plaintiff then appealed to the Sixth Circuit. Next slide. The Sixth Circuit ended up affirming, stating in relevant part, quote, plaintiff asked us to hold that the limitations period for an FCA retaliation claim does not run until the plaintiff knows of the facts giving rise to a claim. That approach, however, flatly contradicts the statute's text, which starts the clock when the retaliation occurred, not when it was discovered. Next slide. Another noteworthy retaliation case is the case of Florida Rehab Associates v. Health South, a case out of the 11th Circuit. In that case, a physician alleged that Health South had retaliated against the physician after she complained about alleged fraudulent diagnosis created to obtain certain Medicaid funding. The district court granted summary judgment for the defendant, finding that the plaintiff could not show that she had a, quote, objectively reasonable belief that the defendant was violating the False Claims Act, given the facts presented. The plaintiff then appealed to the 11th Circuit. Next slide. The 11th Circuit ended up affirming the district court, stating, quote, there's no dispute that the plaintiff possessed sincere subjective belief that the defendant was committing fraud by using fabricated diagnosis, but the plaintiff's belief was not objectively reasonable. Next slide. Yet another retaliation case, noteworthy one out of the 3rd Circuit this time, is the case of Ascalise v. Shoemaker Construction. In that case, it was a quality control manager for a public housing project that alleged that his employer retaliated against him for trying to stop the construction manager from falsely certifying compliance with safety requirements in order to get paid by the government. The district court dismissed that suit, finding that the plaintiff failed to put his employer, quote, on notice of the distinct possibility of False Claims Act litigation. The plaintiff then appealed to the 3rd Circuit. Next slide. The 3rd Circuit ended up reversing the district court and clarified that post-2009, the, quote, distinct possibility of False Claims Act litigation test is no longer applied. Rather, the current test is whether the plaintiff, quote, pled facts that plausibly showed the employer was on notice. He tried to stop the employer's alleged False Claims Act violations, end quote. Next slide. With that, I'm going to kick the slides back over to my friends.
All right, thanks, Aaron. Next slide. So there's an interesting kind of issue regarding Chief Compliance Officer certification. So this past March, the Assistant Attorney General for the Criminal Division, Kenneth Paletti, was giving a speech at NYU Law's program on corporate compliance and enforcement. And in those remarks, he described what DOJ considers when evaluating corporate compliance programs. And he spoke about, the questions that DOJ ask themselves when they are evaluating a compliance program. Is it, one, is it well designed? Two, is it adequately resourced and empowered to function effectively? And three, do they work in practice? And in the interest of time, I'm not going to kind of read off the myriad questions that he outlined. I did find them interesting, but none of them were especially new concepts, and his remarks can be found on DOJ's website. Instead, I want to highlight and talk about what he ended his remarks with, which is something that was new. He concluded his remarks by saying that for all of DOJ's corporate resolutions, that's whether it's by guilty plea, by deferred prosecution agreement, or non-prosecution agreement, that he has asked his team, those in the criminal division, to consider requiring that both the CEO and the CCO, the Chief Compliance Officer, certify at the end of the term of the agreement. So, for example, if there's a monitorship agreement, or the term during which there's a monitoring period for a DPA or an NPA. So at the end of the term of the agreement, that there would be a certification that the company's compliance program is reasonably designed and implemented to detect and prevent violations of the law, right? With a focus on not all laws, but the nature of the legal violation that gave rise to the resolution, the criminal resolution as relevant, and that the compliance program is functioning effectively. And he said that in certain circumstances, they're going to require additional certification language, and it's unclear what additional certification language that is. In reading the remarks, they were quite interesting, and so I think it's kind of clear what's behind it. When the Assistant Attorney General began his remarks, he began by saying, he's been in the position of being a prosecutor, he's been in the position of being a defense attorney, and as a chief compliance officer, and that he found being a chief compliance officer was the most challenging of the three, because there were resource challenges. He identified challenges in accessing data within the company, and what he called relationship challenges. So that was in the beginning of the remarks. And then when he was concluding with this news about this new certification, he said that, that this new certification wasn't punitive, but rather a new tool for chief compliance officers to combat those challenges that he had began his remarks with. So he announces that in March, and then 2 months later in May, there's the Glencore case, in which Glencore, a company, pleads guilty to FCPA and commodity price manipulation violations, and pays over $1 billion in fines. And as part of the plea agreement, agrees to a 3-year monitoring requirement. The plea agreement includes an attachment H that provides this new certification, which said that, within or I guess at the 30-day mark before the end of the monitoring term, the CEO and the chief compliance officer have to certify that the company has implemented a compliance program that is reasonably designed to detect and prevent violations of the FCPA and other anti-corruption laws, and explicitly states that they would be subject to prosecution under 18 USC 1001 if the certification was false. A couple of thoughts on this. One is whether whether it will be effective or whether it will just unduly scare CCOs. But the language is also a little bit different in that the certification uses the term reasonably designed for the compliance program, whereas the DOJ's guidance, that's called their evaluation of corporate compliance programs document, uses the term well-designed. I don't know that whether there's any difference there between well-designed and reasonably designed, but I think the more important issue is that under either use of either of those terms, it's somewhat subjective and hard to determine with any sort of objective lens whether or not the standard has been met. Do others have thoughts on that? If not, we'll turn to the
I
next.
have thoughts.
All right.
I'm not sure they should be shared in a public forum. I was going to make a snarky remark about DOJ providing these tools that will be so helpful to chief compliance. I mean, the compliance officers that I've talked to about this are aware of it. They're following this development. I don't know that they are welcoming this move by DOJ as an effective tool to leverage problematic relationships within their organizations, but we shall see. I think, Andy, to your last one, that was it. I had not focused on the language of the Glencore documentation versus the DOJ policy, versus this notion, is it the sentencing guidelines that talk about effective? Well, I think just generally, we now talk about effective compliance programs. I think both versions that you cited are better language than effective, because of course, if you're in the CCO or the CEO position signing that certification, you're just waiting for 3 weeks later, somebody finds a violation and you're in it again and you're facing personal liability potentially for being ineffective at preventing violations of law.
Yeah, I think it's going to be hard to convince folks that whether it's DOJ or whoever aren't going to look at this with kind of 20/20 hindsight, right, vision, and
Right.
if something happens down the road, and that isn't going to make folks very comfortable. And it's going to create, I think, some problems for companies at the end of these monitoring terms when a CCO may not be willing to sign the certification just because he or she just has cold feet, and it's awfully hard to get them to the comfort level on what's ultimately going to be kind of a legal issue. So
right. We'll see how this plays out, but yeah, interesting. And leads us into our next topic. Can I take the baton? All right, let's take the next slide. Thanks, Andy. And let's move on to the next one. This is our obligatory annual, having the False Claims Act experts talk about FCPA. It's not the same statute updates. So this year we get 3 slides on this because this was interesting and sort of dovetailing exactly with the comments Andy was making about DOJ announcements and maybe some unintended consequences of when DOJ issues some of its policies. But specifically for Foreign Corrupt Practices Act, we did see in 2022 a little uptick in FCPA prosecutions. There was a different DOJ, it was the PDAG, spoke at the FCPA conference here in DC. I think it was early December. It was early December of 2022. And some of the things that she highlighted in her remarks is okay, we've had some fairly significant FCPA resolutions in the last year, which is all good. Some of the themes that she hit on with the resolutions that she talked about is this notion that DOJ in the United States is starting to really see the fruits of its efforts, where the United States was kind of out in front with these issues on public corruption, effectively bribes being paid to foreign officials. The United States was way out in front on these issues for a while, but has done, now DOJ does a pretty good job of incorporating and cooperating with other governments, with foreign governments to pursue, to investigate and prosecute these cases. And so again, go back to early last month, early December, these were the resolutions that the PDAG was touting. Was the stair cycle resolution that was $80 million plus a deferred prosecution agreement to resolve charges that the company had paid, tens of millions in bribes, like really cash payments, like good old fashioned, like cash in an envelope or in a paper bag to foreign officials in Brazil and Mexico and Argentina. So again, with her theme of we're working cooperatively with these other governments, the Glencore resolution was a substantial resolution, has been the subject of a lot of buzz within those who really focus on FCPA investigations, because 1.1 billion, anything with a B, you don't sneeze at. That resolution covered both FCPA violations and some price manipulation schemes, and was coordinated both criminally and civilly among the US, the UK, and again, Brazil. Glencore basically just ate it in the DOJ press release, at least. And then next slide. Again, early December, we're talking about the GOL Linus Airlines case. Again, a $40 million resolution, deferred prosecution agreement, payments to officials in Brazil. A little bit different scheme here. The bribes were to pass favorable tax laws. So from the FCPA authorities in the United States and in Brazil and other places are looking not just at corruption in contracting or manipulation of markets, but this was an interesting one because it really is sort of a public corruption type of issue. That particular resolution, again, was sort of touted by DOJ as, hey, look, we reached this resolution. It's a significant resolution, but note that there was no monitor required because the company really redesigned its anti-corruption compliance policies before we got to the DPA. So sort of the carrot and stick. We've done really well coordinating with other countries and really bringing these substantial investigations, bringing them to resolution, but also consistent with where this unit has been in the past. We want companies to come forward and self-report. And we'll work cooperatively with companies that do that and who remediate and those sorts of things consistent with more recent years DOJ policy. So the PDAG concluded her remarks in early December, and like a week later, DOJ announces all these other big FCPA resolutions. So the ABB limited resolution, $350 million, and a DPA was announced in December. And that resolution was notable, again, sort of going to what the PDAG had said earlier in the month or the week before, bringing new countries and new governments into these investigations. To my knowledge, it's the first investigation where the South African government was also involved in the investigation and resolution of that case. And then the UOP resolution, 160 million. So they had a great December. As you know, I'm sitting here like trying to collect nickels and dimes from all of my clients at the end of the year. DOJ FCPA unit was doing great at bringing in the payments. So the UOP case again involved Brazil and bribe payments there. A little quieter announcement again in December was the Saffron case. And that was an overall declination by DOJ, and again, sort of highlighted the points that the PDAG had made, previewed the week before. So really it was a declination of any sort of prosecution based on a voluntary disclosure because the company had remediated and they disgorged the amounts of the bribes that were at issue. If I'm remembering correctly, the company, when it came in, was able to show that, my understanding of what happened was that there were some issues flagged in a pre-acquisition due diligence effort. So the acquiring company came in, did an investigation, put in remedial measures, and was able to come forward on a voluntary disclosure basis and work out that resolution. So hop in December for the FCPA unit at DOJ. Next slide. And so bigger picture, and again, part of what was announced at the end of the year on the FCPA side was, hey, look, back in September, when there was this announcement about how DOJ is going to approach corporate prosecutions, there were a couple of specific elements that really kind of dovetailed with the view that the FCPA unit has had for a number of years. They do want to encourage companies to self-disclose, and are now looking for examples of here's how a self-disclosure will benefit you when we reach a resolution involving FCPA violations. Pointed out that there was some talk last year about the scope of what previous misconduct will be considered when DOJ is making prosecution decisions. That second sub-bullet should say recidivism is not an aggravating factor that DOJ will consider. So maybe they'll consider recidivism, but it doesn't weigh in if there's been cooperation. And then the promise that monitors, which again caused a big flurry, a buzz last year when there was this announcement about the renewing the DOJ monitoring program, but again, offering the carrot from DOJ that if a company has been proactive with its compliance efforts, comes in, self-discloses, there's an opportunity to forego a potential monitor. And one thing, again, this is going back to the PDAG's remarks at the FCPA conference in early December. She highlighted, and again, this was previewed in the September announcement, DOJ is concerned about and trying to come up with some guidance and some positions that it will have on the use of personal communications devices and encrypted messaging apps, and how DOJ views a company's obligations to be able to control and preserve and potentially to produce information off of those systems. And I think that I will again make a prediction that sometime in the next year, we may hear more from DOJ about its views on that. And that's something that I think companies should have their eyes on, because that really, if you just think about the number of people doing work on personal devices or using Slack or other messaging systems that are either encrypted or don't preserve messaging, it's something that DOJ is concerned about, and I expect that we'll hear more from them on that. All right, we've got a few minutes left. I think that Aaron, are you up to talk about, we're moving on to trends and forecasts.
Yeah.
Next slide. I think Aaron, you're up to talk about private equity.
Perfect. Okay, so wanted to highlight some trends and some forecasts. Last year, we talked a lot about CARES Act fraud and fraud arising out of the Paycheck Protection Program. Expect those issues to continue in 2023 and probably beyond. But one thing we wanted to highlight, particularly for the government contracts community, is the intersection of private equity and the False Claims Act. Private equity is becoming increasingly involved in the government contracts space, and that's why I think this issue is particularly relevant to this audience. Going back to 2021, there was some notable developments, and again, we expect to see this activity continue and in fact increase. Going back to June 9 of 2021, there was a case, U.S. District Court for the Central District of California, where the court denied a private equity firm's motion to dismiss False Claims Act case against it and its portfolio companies. Last I checked, that case is currently in discovery and actually has the potential to go all the way to trial. So stay tuned on that one. Another notable development on this front was in July of 2021, when the Department of Justice announced a $1.8 million settlement with a private equity firm that was based on allegations that it discovered alleged fraudulent activity of its portfolio company during a diligence check, but took no actions to stop it. Now, that basic fact pattern right there is one that we expect to see more and more of, so pay attention to that one. And then another one was from October of 2021, where it was announced that a private equity firm and two executives agreed to pay a total of $25 million to settle a False Claims Act suit, alleging fraudulent billing to Medicaid. So again, we're seeing private equity involved in the government contract space more and more. So certainly something to be aware of and keep an eye on. Next slide.
All right, I think this is me to talk about defective pricing. So this is another one of those areas where, you know, you could bring a case under TINA, you could bring a case under the False Claims Act, but they're often brought under the False Claims Act. So about 3 years ago, the Department of Defense announced that it was going to increase audits of cost of pricing data under TINA. And anecdotally, you know, that seems to have been borne out based on our conversations with clients. And, you know, over the years, this is not a new thing, but over the years, we've seen a number of matters that are, in my opinion, really contractual disputes that involve TINA that get turned into FCA matters. It was about 5 years ago, I think it was, that one of my partners, David Bodenheimer, who literally wrote a book on defective pricing, handled one of those matters for a large defense contractor and largely defeated the government's claim of what was $44 million in defective pricing. So that would be single damages. And that case settled for $3 million after the Army's parallel efforts at the ASPCA to contractually claw back that amount for alleged misstatements during contract negotiations failed. And so fast forward to this past year, and there's at least one TINA case that was pursued as an FCA matter, and that was this Power Secure matter that settled for $8.4 million. This was not a qui tam suit, so I believe it was likely triggered by an audit and a DCAA referral. Power Secure had been awarded a sole source contract for the repair and restoration of Puerto Rico's power grid after Hurricane Maria, and allegedly had failed to disclose certain cost of pricing data when it was negotiating that contract in 2017. And specifically, it was alleged that it had failed to disclose the rates that it had used on a project in Florida and Georgia, not in Puerto Rico, but in Florida and Georgia, after Hurricane Irma in 2017, also 2017. And the alleged price inflation was $6 million. And again, it settled for $8.4 million. I don't have like all of the detailed facts of that case, but certainly I think in reading it, I had a number of questions because when you look at TINA issues, you always have to look, as David Bodenheimer has taught me, to look at the 5 points of defective pricing, right? Is the information cost or pricing data? Is that cost or pricing data reasonably available to the contractor before the date of price agreement? Was it disclosed or known to the government? And did the government rely on the defective data? And was its reliance on the defective data, did it cause an increase in the contract price? So, here, whether or not there's really an apples to apples comparison between, rate for Puerto Rico versus Florida and Georgia is an issue. And given the temporal proximity, what did the government know about the rates anyway, are certainly questions that I would have. And to state the obviously a TINA violation doesn't necessarily equate to an FCA violation, given the different CANTR standards and the like. But given that DOD had announced this increase in audits just a few years ago, I imagine we will also see more and more of these defective pricing FCA cases as the next few years progress. So, next slide.
All right. I think this is our last slide. So can I close us out with this one? I'll again make really modest, I feel safe predictions that healthcare fraud issues will continue to dominate FCA cases, recoveries. I think the hot areas, again, this is healthcare, but some of the issues that we've been talking about, again, sort of bleed over whether you're talking about a healthcare fraud case or a procurement fraud case. So I think Medicare Advantage cases are we'll see more of those. Several of those cases are being actively litigated. And I think what we'll see is some of the defenses that are available, whether you're a healthcare provider or a contractor, will come into play in those cases. So in the Medicare Advantage cases, I expect that we'll see a bunch of Safeco style arguments. Are the regulations ambiguous, or the standards that the plans apply to risk scores and the like, are those ambiguous, and was an interpretation that was taken? Telemedicine, I predict we'll see some more out of that. That's again fallout from COVID to a certain extent, where the telemedicine restrictions were really lifted and now have become more entrenched in more openings for telemedicine companies. What I observed over the last couple of years, when there were big telemedicine enforcement actions, the telemedicine companies had been engaging in bad behavior, shall we say, for a period of time before COVID, and COVID just heightened the issues. And typically with the telemedicine companies, you really are typically talking about the anti-kickback statute issues and sort of patient brokering and unnecessary medical services, but at a cost, at payments to the telemedicine companies. So those are the areas where I think healthcare will be hot, and I think those cases will help us flesh out some of the legal and policy developments that we see coming through the courts and through DOJ. So stay tuned till next year, more to come. And thanks everyone for sticking with us. I'll hand it back over to Alan.
And a big thanks to you, to Andy and to Aaron, both for the preparation and really for the analysis, because lots of people can read cases, but it's folks heard me say, but not everybody has heard me say, it's not just the what, it's the so what behind these cases that really is important for the learning. And you've done a great job in that presentation. Let me also thank our event sponsors for their support. They're listed on the next 2 slides here. And please engage with them as you see fit. Thanks, and enjoy the rest of the day.